the earlier start date, so we'll have people trickling in. But welcome to the last event of the Federalist Society. Today we have with us Professor Doug Kmiec. He's one of America's best-known scholars and popular commentators on the law. Professor Kmiec, you can go ahead and keep that. Door open. Keep it propped open for another 5-10 minutes. Yeah. Professor Kmiec is one of the most best-known scholars and popular commentators on the law. He holds endowed chair in constitutional law at Pepperdine Law School. For those of you who don't know where Pepperdine is, it's in sunny Malibu, California. He came to this position after serving several years as dean and St. Thomas More Professor of Law at the Catholic University of America in Washington, D.C., and for nearly 2 decades on the law faculty at the University of Notre Dame. As dean at Catholic University, Professor Kmiec helped move the law school from up to the upper tier of the U.S. News ranking from the 3rd tier. And at Notre Dame, he was director of Notre Dame's Center on Law and Government and the founder of its Journal of Law, Ethics, and Public Policy. Beyond the university setting, Kmiec served as Presidents Ronald Reagan and George Bush during 1985 to 1989, and as Constitutional Legal Counsel, Assistant Attorney General, Office of Legal Counsel, Department of Justice. A wide-ranging writer and engaging speaker, Professor Kmiec writes a syndicated column for the Catholic News Service, and for several years wrote a regular column in the Chicago Tribune. He's also a frequent contributor to the pages of the LA Times, Wall Street Journal, and other periodicals. He is the co-author of 3 books on the Constitution, and has written also on matters more culturally and related to family. He also has done scholarly research that spans legal and non-legal subjects, from the Constitution and the federal system to land use and the organization of American society. He is a frequent guest on national news programs such as Nightline, the NewsHour, and NPR's Talk of the Nation, analyzing constitutional questions. And with that, I'd like to introduce Professor Kmiec.
Thank you, Patrick, and thank you for inviting me to this wonderful campus. I know the food is the main attraction, so I will try not to detract too much from it. I also know this is your last week of classes, and it is very generous of you to devote part of your time to this discussion this afternoon, which, in all seriousness, I think is one of great importance for all of us, even as I recognize Professor Silman's in the room, and he's already well informed you of the principles involved. Let me begin by noting that I think one of the most overlooked aspects of this issue of terrorist surveillance, and I assume you can all hear me even if I walk away from the microphone, is that right? Good. Is the fact that there is general agreement among the contestants about the need for surveillance. So if you were setting aside the difficulty, and there is difficulty, if you were setting aside the difficulty of the legal interpretation issue, one would see a common base of agreement about the inadequacy of existing surveillance, at least prior to 9/11 and perhaps even continuing to today. Immediately after 9/11, the president noted the inadequacy of intelligence derived from surveillance, but also the joint inquiry report of both the House and the Senate Intelligence Committees made a formal finding to the effect that there were, and I quote, missed opportunities to unravel the plot through enhanced surveillance within the United States, and in addition made the further factual finding that one of the reasons there was this inadequacy of intelligence based upon surveillance occurring within the United States was that there was a widespread perception that the Foreign Intelligence Surveillance Act was cumbersome, was difficult to comply with, and to quote the joint inquiry report of the Congress, that FISA imposed a process that was lengthy and fraught with peril. So if you start with the proposition that our intelligence is weak or faulty, and part of that reason for that is the inadequacy of surveillance, then you're obviously brought to the question of, do you have the legal authority to enhance it? And the president asked that question of his own advisors. He, to some degree, asked that question of the chair of the Senate Intelligence Committee, Senator Pat Roberts. And he asked the question, of course, of Attorney General Gonzales, and you know the answer each of these people gave, that he had the authority to engage in enhanced surveillance without complying with the Foreign Intelligence Surveillance Act. And my own supposition, not to keep you in suspense, is that I believe the conclusion that these advisors gave to the president is constitutionally reasonable and reasonably plausible, even beyond my own constitutional speculations. Now, that means it has to be, this authority of the president has to be somehow made compatible with the Foreign Intelligence Surveillance Act. The Attorney General's case for that is to point to that portion of Title 50 that says that, yes, surveillance shall be conducted under this act as the exclusive means of conducting it, except as authorized by statute. And the Attorney General's argument is that that invitation for authorization by statute is an authorization for Congress to supplement the Foreign Intelligence Surveillance Act with authority for the president that the president and the Attorney General derives from the authorization for the use of military force. So one argument that the president makes and that the Attorney General makes for this grant of authority is one that's simply a construction of the statute. That the FISA statute doesn't say as otherwise authorized by this chapter. It says as otherwise authorized by statute, and the president points to the authorization for the use of military force. My own sense of that statutory construction is that it's a bit implausible. That while it works in a formal sense, it is not one that I think one can demonstrate from the standpoint of legislative history if Justice Scalia is looking the other way and we consult legislative history, or otherwise sustainable in terms of the structure of that statute. So then how do I reconcile this claim of presidential authority if not on the basis of this kind of open-ended statutory phrase? I think more persuasive for me is the discussion that Griffin Bell, Attorney General to President Carter at the time FISA was being enacted, had with the members of Congress as they were drafting with the statute, and the result of that conversation. The result of that conversation is an acknowledgement that FISA, by and large, is not intended to be a wartime statute. FISA originated, of course, in part because of the domestic abuse of surveillance activity by former President Nixon and other executives who were using surveillance authority to, in essence, spy on what would be legitimate First Amendment activities. And it was important for the Congress of the United States to address this abuse of executive authority and to stop it. And FISA is largely an answer given by the Congress of the United States for that executive abuse. FISA also resulted because of a decision of the U.S. Supreme Court authored by Justice Powell, known as the Kmiec case, United States versus United States District Court, which dealt with some of the domestic spying of that era and reminded the executive that Fourth Amendment principles applied to domestic surveillance undertaken in the name of national security. Justice Powell drew some categories in that case. He said, domestic surveillance for purposes of national security is in a different category than surveillance for purposes of criminal investigation. And therefore, one didn't have to have the same level of probable cause, the same showing of particularity that you would need to have for a Title III warrant in the criminal process. And Justice Powell articulates in the Kmiec case the proposition that if Congress so chose, they could create a specialized court to handle the considerations, the unique considerations of probable cause as they related to the conduct of surveillance domestically with regard to matters of national security. So notice right there, Powell, in the opinion, is creating two analytical categories. The probable cause showing that one needs for a criminal warrant, and the probable cause showing that one needs to conduct surveillance for purposes of national security domestically. But then he creates yet a third category. And the third category is really more of a footnote than an extended discussion by Justice Powell. And the footnote is that, of course, he means not to say anything at all about the ability of the president to engage in surveillance for purposes of gathering foreign intelligence information. So you end up, as a result of Supreme Court opinion, with the hint from the Supreme Court that intelligence gathering in the foreign context is outside of the parameters of the Fourth Amendment altogether, that domestic surveillance for national security purposes is inside the ambit of the Fourth Amendment, but differently and more loosely than criminal warrants that, of course, require a showing of probable cause, meaning that a crime is about to be committed or has been committed, and a showing of particularity and so forth. Congress decides when it drafts FISA that it is going to govern both of those national security categories, domestic surveillance and foreign surveillance, which is more than Justice Powell seemingly invited them to do. And instead, the Congress draws on its face the distinction between surveillance of U.S. persons and foreign agents or agents of a foreign power. The showing of probable cause under FISA is different if you are seeking to surveil a U.S. person. There you have to show that the U.S. person is related to some predicate criminal activity, such as espionage or sabotage or the material assistance of terrorism. But with regard to undertaking surveillance of a foreign power or the agent of a foreign power, you must merely certify that that's the fact, that in fact this person is an agent of a foreign power, and that the equipment that you're seeking to surveil is the equipment that he's using, and so forth. Now, where does this leave us in terms of the President's current activity? Well, it leaves us exploring the issue of, was FISA intended to apply to wartime? And if it was intended to apply to wartime, how does it apply? And this brings me back to Griffin Bell's commentary. Griffin Bell, when he testified about FISA, pointed out that Congress had to be careful not to speak to that third category, namely the President's ability to engage in surveillance for purposes of gathering foreign intelligence information. But Congress chose to speak to it nonetheless. They tried to satisfy the concern that Bell raised by creating an exception for wartime that would allow the President to undertake surveillance for 15 days after the formal declaration of war. Now, does that mean realistically that Congress thought all wars would last 15 days? And the answer is self-evident. Of course, that's not what it meant. And indeed, again, Justice Scalia notwithstanding, if one does consult the legislative history, one sees that the purpose of that 15-day exception was to give Congress the opportunity to pass supplemental legislation to deal with the nature of intelligence gathering in wartime. Have they done that? And here's where, of course, you get a debate about the authorization for the use of military force that was enacted by Congress following 9/11. It is fair, if we're going to answer that question, to examine the language of the authorization for use of military force. And that language is quite broad and quite expansive. And it provides that the President shall be able to take all necessary and appropriate force against nations, organizations, or persons that the President determines planned, authorized, committed, or aided the events of 9/11, or such entities, again repeating nations, organizations, or persons that harbored such organizations in order to prevent any future acts of international terrorism against the United States. Now, does that authorize surveillance of the type that the President has undertaken? The President argues that it does simply by its sweep. And indeed, he is on reasonable footing when that authorization for use of military force is compared to other contemporary authorizations for military force that have been issued with regard to the first Persian Gulf War in 1991, in Lebanon, in Somalia, and elsewhere, all of which with regard to scope, duration, target, resources, are far more conditioned or narrowed than the authorization that's granted after 9/11. Second, the President would point to the construction of the authorization for the use of military force that was given to it by the Supreme Court in Hamdi. And of course, the quotation that you hear from Hamdi most often is that the President doesn't have a blank check. And that's a fair statement. But the statement you don't hear is that the plurality of the court largely acknowledged as well that the president has a substantial deposit of authority. It's a deposit of authority that the Supreme Court said might well include a substantial amount of inherent power, but they didn't need to reach that. And so the plurality in Hamdi expressly said, even without reaching the scope of the president's Article II authority as commander-in-chief to address the question in that case of detention, we will confine ourselves to the analysis of the authorization for the use of military force. And in confining ourselves to that authorization, we'll construe it in such a way that it overcame an express prohibition of the detention of American citizens under the Non-Detention Act. The authorization for the use of military force, I believe it's September 18th, 2001.
Okay.
So, no, it does not. There are separate authorizations for both Afghanistan and Iraq, and there is an authorization for the use of military force passed on September 18th. So, the president looks at the language, all necessary and appropriate force with respect to persons, looks at its purpose to prevent a further terrorist attack, looks at the Supreme Court's interpretation in Hamdi that interprets this enactment as including all of the incidents necessary to wage war successfully, including in Hamdi the ability to detain an American citizen as an enemy combatant, subject, of course, to the qualification that the court provides in that case, that the enemy combatant be given a reasonable opportunity to contest his detention. But, of course, that reasonable opportunity comes with a presumption in favor of the government's exercise and also comes with the statement by the plurality that the president would be able to rely upon sources of evidence and materials that would not be readily available in a normal criminal proceeding. So a statement of balance, if you will, attempting to balance the president's power with the civil liberties that we would normally associate with American citizenship. Now, what's the argument against the authorization for the use of military force? Well, the argument as a source of authority. The argument boils down to the proposition that members of Congress did not specifically contemplate that they were authorizing surveillance at the time that that they were passing the authorization for the use of military force. It's an argument basically from the specific intent of contemporary members of Congress. Russ Feingold and others would basically say that's not what we're thinking about. We didn't have that in mind. In truth, I doubt that they had in mind the detention of American citizens either as enemy combatants. So one response would be to say you have to live by the written word of the law and not your subjective intent. But the further argument is, of course, that FISA, the more specific statute, should govern over the authorization for the use of military force, the more general statute. Now, I thank you for your question because, of course, the president has a response that says, well, the more specific statute is earlier in time than the later in time authority given to me to exercise military force, including, in his judgment, the power of surveillance. But you can see how the canons of statutory interpretation, which don't give you answers generally, also don't give you answers here. There is a principle of constitutional avoidance that I think is also fairly raised in behalf of the president, however. And it is the fact that it's not just that the authorization for the use of military force is second in time to FISA, but that it is an acknowledgement of what the Supreme Court of the United States said it didn't have to rely upon in Hamdi, but nevertheless shouldn't be made invisible to our analysis. And that is the scope of the president's power as commander-in-chief to prevent attacks against the homeland. Authority recognized, as you know from your constitutional study, in the prize cases from the Civil War and Abraham Lincoln's ability to respond to the Southern attack on the sovereignty of the United States, but is also repeated and elaborated in Justice Sutherland's opinion and Curtis Wright, and is relied upon modernly by the Supreme Court in Dames and Moore and a host of other cases. So that the president would say, even if there is doubt about the applicability of the authorization for the use of military force, when that doubt is reconciled with my Article 2 authority, the doubt is resolved in my favor. Now, this was a hot issue a couple of weeks ago. It's still a very important issue today. This is an issue of such importance that when FISA was being fashioned, the existing activity of the National Security Agency as it related to the gathering of so-called signals intelligence, which was, as I understand it, one of the principal ways in which the United States keeps track of its adversaries, was deliberately accepted, accepted, out of the definition of electronic surveillance of the Foreign Intelligence Surveillance Act, showing a recognition, again, on Congress's part, that they didn't want FISA to hamstring the president's constitutional authority to defend us in times of war. Notice we then have two building blocks for that proposition. The 15-day exception that says, Congress, contemplate the additional legislation you need in a time of war when it occurs. Know what scope of authority the president should be given in light of the facts then on the ground. But also, one of the facts we know presently is that the NSA's gathering of signals intelligence is a form of military intelligence that ought not to be interfered with by the general regimen of FISA that we are putting in place, also illustrating what is a common fact, that when you are in a battle, you surveil your enemy. And you do that without the encumbrance of warrant or other consideration. And of course, the president would point out what we all recognize from 9/11, and that is, whether we like it or not, where we live is a battlefield. I suggest to you that last statement is contested, even as it is nominally agreed to. On 9/11, I was the dean of a law school in Washington, D.C. On 9/11, I lost two friends. You may have lost family members or friends as well. But I lost Professor Karen Kincaid, who was on my communications law faculty, who had just boarded a plane earlier that morning to attend a seminar in California. Her plane, of course, ended up in the side wall of the Pentagon. Also on that plane was Barbara Olson, a personal friend. You know her well as an author and commentator and the wife of Theodore Olson. And of course, we all lost thousands of countrymen, whether we know it or not. On that day, I could say to you, and there would be general agreement, that we are at war, that our homeland has been attacked, and this is a battlefield. But saying that in 2006 has less resonance. And I think one of the lurking features of this debate about the president's authority is that 5 years away from the event, many of us are no longer sure whether we are at war. And that we have reconceptualized the problem in our mind as a problem of addressing some form of virulent organized crime that when we're lucky enough to nab one of the kingpins, we will just plug into the normal criminal process and punish. Whereas from the president's perspective, he has retained the perspective of 9/11 and therefore sees this as an ongoing war where the foremost obligation that he has is not punishment, but prevention. And I believe he has structured the surveillance program accordingly. Now remember where we began. We began with my premise, which I believe is largely shared in the Congress, that weaknesses in surveillance made us less prepared than we would have been for 9/11, and that there is a common agreement that weaknesses in surveillance and the gathering of intelligence may make us weaker than we should be for purposes of preventing a further attack. If at least that premise is true, even if the Janus face of this war now presents itself as something less than war, at least in the popular mind, what is the next appropriate step in this debate? Now, as partisans, if we wish to be partisan, we could continue the debate indefinitely. My friend Professor Tribe from Harvard could come in and point to the language of FISA and say, FISA is intended to be the exclusive means by which surveillance is done, and keep underscoring the word exclusive. Not a bad argument. It's a statutory argument. It's one that has to be reasonably respected. But of course, then I can march in and say, but FISA has this statutory exception for other statutes. FISA has this exception for wartime, contemplating further legislation. FISA was drafted to exclude military intelligence. Professor Tribe, explain all of that to me. Explain how it is that FISA was deliberately crafted in a way to, in essence, exempt war. And we would be at loggerheads. And he's smarter and prettier than me, so he might prevail in the statutory debate. But that would be cosmetic. Because the real concern would continue. The real concern is the premise we started with. Do we need to improve our surveillance capacity to prevent another attack? And if we do, then the question is, what are the reasonable steps for Congress to take? So let me just outline briefly, if I can, the schedule of things that are on Congress's plate. And then we can talk about them in questions and so forth. One of the things that I was invited to testify before the Judiciary Committee at the end of February about was legislation called the National Security Act, National Security Surveillance Act, proposed by Senator Specter. Senator Specter has doubts about my argument. And similar arguments that say the authorization for the use of military force is an authorization for this surveillance program. And therefore, his solution is to resolve that doubt by giving it to a court, namely the Foreign Intelligence Surveillance Court. And he would create something known as a program warrant that in essence would invite the members of the Foreign Intelligence Surveillance Act Court to pass upon the constitutionality of the president's program after it was presented to them. Now, think about the principles of constitutional law that you've already learned well. Do courts pass upon advisory questions? The answer, of course, is again self-evident. They do not. Article 3 requires a case or controversy. But, Senator Specter would say in response, when a warrant is being applied for, there is not necessarily in a formal sense a case or controversy yet. A search warrant is for purposes of investigation, which may lead to a criminal case, but there may not be an extant one. And so his response is to say, insofar as the very nature of the granting and consideration of warrants is a judicial function, then there's no reason why you can't expand the authority of a court not just to issue warrants with regard to individuals, but with regard to programs altogether. And he has some authority for that proposition. But his authority butts up against some things like courts aren't intended to give advisory opinions, an old case called Hayburn's case that says courts aren't intended to perform administrative functions, and even the historical distaste articulated by the founder, James Otis, against writs of assistance and general warrants, which program warrants might resemble. So there are some real constitutional problematic questions in the Specter alternative. You can argue them both ways. A competing proposal, which the president likes much better, is one from Senators DeWine and Graham. And that would basically allow the president to continue his existing program for 45 days. And if during that 45-day period his method of surveilling these international calls into or out of the United States to Al-Qaeda or an affiliated organization identifies a specific individual, then the Attorney General must apply for a FISA warrant with respect to that specific individual, or if he cannot, he must explain to a specialized committee, subcommittee of the House and Senate Intelligence Committees, why that is the case and why national security should permit him to continue his method of surveillance without a FISA warrant. So in essence, the balance struck by the DeWine-Graham legislation is one that is more accommodating of the president's existing program, but nevertheless cognizant of civil liberty to the extent it can be protected once someone is specifically identified and targeted for purposes of surveillance. It also has the advantage of creating a specialized terrorist surveillance subcommittee. One of the findings of the Joint Inquiry Report after 9/11 was that too many committees were involved in overseeing the executive's intelligence gathering activities, and too few people in Congress were building up the expertise to even know how to ask the right questions. One of the things the DeWine-Graham proposal has going for it is that it's creating this specialized body that presumably would be serving long-term and would build up that expertise, and also have the salutary benefit of narrowing the risk of unwanted disclosure. Those are two proposals. They're competing with each other. There's a third from Senator Schumer. Senator Schumer's stuck on the authority question. Rather than moving on and admitting the premise that we need to improve our surveillance capacity and to do it lawfully and openly, he wants to just litigate the constitutional question of whether the president has violated the law. And so he's prepared legislation that ostensibly creates standing for any individual who would have engaged in a conversation, an international conversation, but for the fact of fearing that they would be subject to surveillance. And that is his described statutory injury in fact. Now, you know the case law in this area. It's the Lujan case, it's the Laird case, it's a number of related cases. And there is a plausible argument, if you're Justice Ginsburg, that Congress can create standing of this type. There is an implausible argument, if you're Justice Scalia, that Congress can't create standing in citizens where no factual injury actually exists. This statute actually is a close question as it's drafted in terms of the makeup of the court and the law as it exists. But notice that the statute as it is proposed is unlike the previous two I described because it is, in essence, merely a way to legally prove or disprove whether what the president undertook had been authorized. So it doesn't address the future as directly as the previous two do. And then, of course, there's Senator Feingold, who wants to censure the president for undertaking the surveillance program in the first place. This may or may not be related to the senator's possible presidential campaign, but it does not look like it is related to actually helping us resolve our weaknesses in surveillance that give us weaknesses in terms of intelligence. And let me just end and take questions with this thought. There's a lot of quotation these days of Robert Jackson. You all know the quotation. It's the admonition in the Youngstown case where Robert Jackson creates his famous 3 boxes or 3 categories where the president is at his zenith if he acts together with Congress. He's in the twilight zone where Congress hasn't spoken, and he's at his lowest ebb of authority when he is relying solely upon his inherent power and acting against the wishes of Congress. Where is President Bush on this issue? Well, the complications of the debate suggest that the president thinks he's in box 1. He has all of the power of Article 2, plus the authorization for the use of military force, which he construes compatibly with FISA in order to avoid constitutional encroachment of executive power. The Congress, at least Senator Feingold, thinks he's in the bottom drawer. Right? They think the authorization for the use of military force doesn't authorize surveillance. They think FISA is the exclusive means of surveillance, and if the president hasn't complied with it, which he's admitted that he has not, he's violated the law. Now, we can stay in that paralysis, arguing that point until we are subsequently attacked and suffer losses, and then once again recriminate about our failure to take appropriate steps to bolster surveillance, or we can try and fashion reasonable oversight that acknowledges that Congress has a significant role in foreign affairs, but it's not one that is designed to undermine the president's active responsibility as well. And that, I suggest to you, is the overlooked part of Youngstown. Because Robert Jackson wrote not for the purpose of inviting litigation and dispute, but for the purpose of seeking to put both of the political branches on the same side in times of war, if we are at war. So let me take your questions. Yes.
I want to ask, you mentioned that the War Powers Declaration was made on the 18th of September?
Right,
So it's 7 days between 9/11 and when that occurred.
right.
And is there at what point in that 7 days was the determination made that it was an act of war versus a crime? Was that, since the crime scene, as far as I'm aware, was not treated as a crime scene because all the evidence was carted away and destroyed? Was there some?
Well, I mean,
critical...
that's a good example of that it wasn't anticipated to be a crime. We don't pass authorizations for the use of military force in response to worldwide criminal activity.
Right. So at what point was it determined that it was an act of war and not a crime?
Well, I think at the moment that was enacted, it was.
Well, where was the proof? I mean, there has to be a proof that determines what something's a crime or an act of war, and where was the proof?
Well, I'm not.
Because that's the basic assumption on which the war powers were granted on the 18th, that there was an act of war committed.
Well, and there's an express recital in the authorization for the use of military force that it is intended by Congress to be an authorization pursuant to the War Powers Act. So that in itself shows, I think, Congress's intent or understanding to treat this as a military engagement, as a war, rather than a criminal activity.
Except there was no declaration of war.
There was no declaration of war.
And
now, but of course,
war was by proclamation, essentially.
yes. And here we get into this modern circumstance of not utilizing formal declarations of war very much in our history, right? As you know and I know, there have been hundreds of military interventions and 5 declarations of war. That's not to excuse that practice, but it is a reality, and it has a historical explanation that the notion of declaration of war was largely for the purpose of adjusting our relationship in terms of foreign relations in light of hostilities. In other words, the formal declaration created consequences of immunity for particular actors who would then take actions thereafter that has lost its significance in a modern sense.
And for some people might categorize 9/11 as the crime of the century. And for some reason, the evidence in the crime of the century was destroyed and is no longer available to us to examine.
And I think your point's a valid one, because I think the administration itself has whipsawed the characterization of 9/11 as both a crime and a war. To the extent that participants in the war, Moussaoui, are undergoing a criminal process. To the extent that participants in the war, Padilla, have undergone both military process and now criminal process. You can see an ambivalence in direction or understanding even on the part of the commander-in-chief.
And the remains of the perpetrators were never discovered. One intact passport was the only thing that was recovered at the scene, despite the fact that all the bodies were shredded into powder. And
Professor?
Professor Kmiec, let me take you one step beyond what you've articulated to us. I think it's clear that the president, had he gone to Capitol Hill in the early days when the Congress was considering the Patriot Act and did make a change to the standard from the purpose to a significant purpose, that had he asked for 1811, which is the declaration of war provision, to be changed in light of what you just said, that we would probably never have a declaration of war again, that it be changed into something like, when there is a national crisis as mutually agreed upon by the President and the Congress, then he shall have this authority to surveil for 15 days, and we wouldn't be having this debate. But is it not true that perhaps what you've been discussing is part of a really larger issue that has to do with the President's overall authority under the Constitution, not by statute, under the Constitution, to prosecute a war, whether you're talking about intelligence techniques, surveillance, detention of enemy combatants, that perhaps the reason the president did not go to Congress to seek specific statutory grant for this is that the larger principle of his constitutional authority as commander-in-chief is really what is at stake. Do you have any comment on that?
Well, I think he certainly sees it that way and characterizes it that way. As lawyers, we like to avoid the big question until the final curtain. In fact, we like to avoid the big question altogether. And indeed, my own study of Supreme Court determinations in times of war suggests to me that the court is very much a minimalist, to pick the Cass Sunstein word, during times of war. Well, you can see it in the Japanese internment cases. Hirabayashi starts with the curfew. Korematsu moves to the exclusion. In-rei Endo moves to the detention. And even when they get to the detention, they don't uphold the detention, and they don't uphold it not because they say the president lacks constitutional authority. They don't address his authority. They just address the civilian authority that was holding the particular Japanese citizen. So I think there is, in my judgment, a salutary basis for taking small bites in terms of the litigation of these questions, only because I think there is too many imponderables in reaching an ultimate conclusion, such that the imponderables go both ways. I think it was Jackson as well in one of those internment cases who said, if we pronounce in the abstract, or maybe it was Frankfurter. Was it Frankfurter or Jackson?
Yeah, well, Jackson in Korematsu kind of avoided the issue, I think.
Right. But also, one of them, Jackson or Frankfurter, has this wonderful phrase that if we opine in the abstract, it'll sit around like a loaded weapon. And the abstract proposition will then be borrowed by someone who wants to abuse authority in a future set of facts that we would like to resolve differently. But, Professor, your insight is exactly correct. This is a debate that began with Madison and Hamilton over the President Washington's ability to declare neutrality. And in their respective letters of Pacificus and Helvidius, they resolved nothing other than one can find apt authority on both sides, as Justice Jackson points out. This ends up being as enigmatic as the dreams of the Pharaoh. And one can find competing levels of authority that one can go on endlessly. But clearly the president, in our behalf, has to stake out his authority as commander-in-chief to make tactical judgments, including the tactical judgment of how to conduct military intelligence on the battlefield. He has to make that argument. Whether the court should reach it and sanction it seems to me to be a different question. I would prefer to see Congress act in coordination with the president to avoid some of the hard issues. You've been very.
I'm sorry, maybe we can, we have to go in 1 minute, so just.
All right, a one-minute question.
You've gone, I'm going to go to it.
All right.
Weaknesses of surveillance is a phrase you've repeatedly used. And in relation to that, number one, you've mentioned the encumbrance of warrant. Given that you have a special court that can handle these quickly, that they can surveil for a time before going to this court, how is this a big encumbrance? Why can't he use it? Number two, you talk about, again, the weaknesses of surveillance, but it seems to me much more, they knew, the administration knew before 9/11, in the middle of August, that they were going to attempt hijackings. Ashcroft refused a warrant request by lower FBI agents to surveil certain radical Muslims that were later involved in the hijacking. So again, it seems not a weakness of surveillance, but glaring incompetence by the administration, and that Bush acts in the way he does because he's kind of a wannabe emperor and he's arrogant, and that's okay.
Okay. Good criticisms, and let me try and respond a little bit. I like your example very much about the pre-9/11 failure to get a warrant with regard to Moussaoui in particular. And part of that problem, Professor Silliman and I were discussing earlier today, may have been solved by the Patriot Act to the extent that the operational people had the conception that law enforcement and intelligence officers could not have meaningful conversations with each other without jeopardizing the process of one or the other, and that has been changed by the Patriot Act's reformulation from, from primary to significant, right?
From the purpose to a significant.
A significant purpose. So there was a structural problem in the statute that existed that doesn't exist now, which may have explained part of the pre-9/11 problem. But now we have to deal with the reality of the reformed statute. I think part of the difficulty for me to respond fully to your question is not knowing the full operations of what the president is up to in terms of his methodology, because all of that's classified. But that's what he says is the problem in terms of his inability to go to the FISA court. He commends the FISA court for being extraordinarily responsive to his petitions, and as you know, they've been very responsive when he's brought petitions to them. My supposition, this is just supposition, I have no classified information. Professor Silliman can have me arrested if I pretend to say otherwise. My supposition is that what's going on is some serious data matching pursuant to algorithms and other formula whereby large numbers of conversations are being examined for warning signs. And that once they get enough of that as a nucleus, they then start zeroing in on particular individuals. Notice how that doesn't fit the structure of the FISA statute. The kind of general surveillance looking for warning signs is not the kind of showing you have to make to get a FISA probable cause warrant, either against a U.S. person or even a foreign national. So you could tinker, with the FISA statute in that regard to try and address the particular surveillance method that the president has. That hasn't been overtly talked about because of the operational details of the program are just simply not known.
All right. I think with that, we'll thank Professor Kmiec for visiting with us.